2020 has been an eventful year, and there have been some absolutely enormous cases decided by the Supreme Court. What are the 10 most important cases decided by the U.S. Supreme Court this year? Let's find out. As far as the criteria that I use to select the top cases, they are strictly based on my personal opinion. Accordingly, your top 10 may differ, and if it does, you should absolutely let me know about it in the comments. Now, let's start off the list with a few honorable mentions. The first honorable mention is Kelly v. United States, which was decided on May 7, 2020, and writing for unanimous court, Justice Kagan threw out the fraud convictions of Bill Baroni and Bridget Ann Kelly. What did these two malcontents do? They closed down the George Washington Bridge and created a traffic jam in New York and New Jersey that lasted for 4 days to punish some Democratic politicians for not endorsing Chris Christie. Why did the court overturn their convictions? The statutes in question required that the fraudulent actions were trying to gain money or profit. While strictly correct, this type of decision will just encourage more loser politicians to pull this kind of nonsense in the future. Let me state that it is extremely important that criminal statutes are interpreted giving every benefit to the accused, because quite frankly, prosecutors already stretch criminal laws way beyond their intended purpose. And if the courts give them more leeway, it would just exacerbate the overcharging epidemic that is raging in criminal courts. There's one more honorable mention, which is Maine Community Health Options v. United States. This was decided in April with Justice Sotomayor writing for the court. The issue in this case was whether the federal government had to pay insurers that offered policies as part of the Affordable Care Act's Risk Corridors program. The court held that the government did have to pay the insurers, which was not really surprising to anyone except for maybe Justice Alito, who was the lone dissenter. Now that brings us to the top 10. My number 10 case is New York State Rifle and Pistol Association versus City of New York. This is a case that a lot of Second Amendment advocates hoped would lead to greatly expanded Second Amendment rights and maybe even a nationwide carry. Instead, it turned into at least a temporary setback for Second Amendment rights and big win for gun control advocates. As background, ever since the court ruled in District of Columbia v. Heller that the Second Amendment provides an individual right to bear arms, one tactic that anti-self-defense jurisdictions have taken is to promulgate onerous Second Amendment restrictions, enforce them vigorously, and wait until they are sued and the case actually makes its way to the Supreme Court, at which point they will rescind the restriction and wait a few months and replace it with something slightly less onerous. The expectation that the Supreme Court would refuse review or find that the restriction was moot because it was already overturned. This decision, which issued on April 27th of this year, effectively endorses that tactic, although I will point out that there is some hope in it for self-defense advocates. What the case was originally about was a restriction that New York had placed on the transport of firearms. Effectively, New York City gun owners were prohibited from transporting firearms outside the city, even to a shooting range or a second home. And instead of allowing the restriction to be reviewed at the Supreme Court, the city, under a lot of pressure from anti-self-defense groups, repealed the restriction right before the case was set for argument. However, as I said before, the most interesting language in this case comes from Justice Kavanaugh's concurrence. As I mentioned in a previous video, with the addition of Justice Barrett, Justice Kavanaugh is probably the new swing vote, so what he says means a lot. And here is the snippet from Justice Kavanaugh. I share Justice Alito's concern that some federal and state courts may not be properly applying Heller and McDonald. The court should address that issue soon, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending before the court. Accordingly, this case is likely a sign of things to come with regards to the Second Amendment. It's pretty clear, especially with Justice Barrett replacing Justice Ginsburg, that there is a 5-4 or possibly 6-3 majority on the court for expanding self-defense protections. The ninth most important case of the year is June Medical Services v. G. This case deals with a requirement by Louisiana that any doctor performing abortions had to have admitting privileges at nearby hospitals. This case is largely a redo of the court's decision in Whole Women's Health v. Hellerstedt, which was decided in 2016 before Justice Kavanaugh joined the court. Pro-life advocates hoped that the court would effectively flip the earlier decision. However, Justice Roberts flipped his vote in this case. And while Justice Breyer wrote the decision for a divided court, the most interesting bit comes from Justice Roberts, whose philosophy of maintaining the dignity of the court is on full display. In July 2013, Texas enacted a law requiring a physician performing an abortion to have active admitting privileges at a hospital located not further than 30 miles from the location at which the abortion is performed. In Whole Women's Health v. Hellerstedt, the court concluded that Texas's admitting privileges requirement places a substantial obstacle in the path of women seeking a pre-viability abortion, and therefore violated the Due Process Clause of the 14th Amendment. I joined the dissent in Whole Women's Health and continue to believe that case was wrongly decided. The question today, however, is not whether Whole Women's Health was right or wrong, but whether to adhere to it in deciding the present case. The legal doctrine of stare decisis requires us, absent special circumstances, to treat like cases alike. The Louisiana law imposes a burden on access to abortion just as severe as that imposed by the Texas law for the same reasons. Therefore, Louisiana's law cannot stand under our precedents. My eighth most important case of the year is Our Lady of Guadalupe School v. Morrissey Baru. As anyone that has ever practiced employment law knows, the rules that govern secular schools and religious schools are very different, and that difference was on full display in this case. This case was decided 7-2, and Justice Alito wrote, "The religious education and formation of students is the very reason for the existence of most private religious schools, and therefore the selection and supervision of the teachers upon whom the schools rely to do this work lie at the core of their mission. Judicial review of the way in which religious schools discharge those responsibilities would undermine the independence of religious institutions in a way that the First Amendment does not tolerate." The court effectively held that there is no judicial review for employment decisions at religious schools. Not a surprise, but an interesting area of law that leads to some very unjust outcomes. My seventh most important case is Espinoza v. Montana Department of Revenue. This case dealt with whether Montana could provide financial support for private schools but exclude religious schools from that support. This case was decided back in June, and in a 5-4 decision, Justice Roberts wrote that the state could not exclude religious schools. In particular, he wrote, "A state need not subsidize private education, but once a state decides to do so, it cannot disqualify some private schools solely because they are religious." Given the trend in many states to start allowing parents to choose between public and private schools, the holding of this case may be very important in the coming years. My sixth most important case is Little Sisters of the Poor v. Pennsylvania. This case dealt with whether employers with religious or moral objections still had to offer insurance coverage for contraceptives. On July 8, 2020, the court held that such employers did not have to provide such insurance coverage. The decision was 7-2, with only Justice Ginsburg and Justice Sotomayor dissenting. Justice Thomas wrote the decision, and I think this bit more or less sums up his decision pretty well. For over 150 years, the Little Sisters have engaged in faithful service and sacrifice, motivated by a religious calling to surrender all for the sake of their brother. They commit to constantly living out a witness that proclaims the unique, inviolable dignity of every person, particularly those whom others regard as weak or worthless. After 2 decisions from this court and multiple failed regulatory attempts, the federal government has arrived at a solution that exempts the Little Sisters from the source of their complicity-based concerns: the administratively imposed contraceptive mandate. We hold today that the departments had the statutory authority to craft that exemption, as well as the contemporaneously issued moral exemption. We further hold that the rules promulgating these exemptions are free from procedural defects. We are now into what I consider the top 5 most important cases of the year. These are all cases that affect at least hundreds of thousands of persons and even every single person in the United States with regards to the most important cases. For number 5, I chose Department of Homeland Security v. Regents of the University of California. This case literally saved the DACA program, which will presumably survive for at least 4 more years, as President Trump will not be in office long enough to take another shot at killing it. The decision was 5-4, and Justice Roberts wrote the opinion. In particular, Justice Roberts wrote, "We do not decide whether DACA or its rescission are sound policies. The wisdom of those decisions is none of our concern. We address only whether the agency complied with the procedural requirement that it provide a reasoned explanation for its action. Here the agency failed to consider the conspicuous issues of whether to retain forbearance and what, if anything, to do about the hardship to DACA recipients. That dual failure raises doubts about whether the agency appreciated the scope of its discretion or exercised that discretion in a reasonable manner. The appropriate recourse is therefore to remand to DHS so that it may consider the problem anew." Theoretically, if the Trump White House had offered a better explanation for terminating the program and given some consideration how to deal with the now illegal DACA recipients, the decision may have passed muster. However, DACA now survives until at least 2025, and who knows, Congress and the President may arrive at a compromise in the meantime. My number 4 decision is Bostock v. Clayton County, Georgia. This decision extended Title VII protections to LGBTQ persons. This was a 6-3 decision with only Justices Alito, Kavanaugh, and Thomas dissenting. In addition, this decision focused on interpreting a statute, Title VII, rather than the Constitution. Effectively, Justice Gorsuch ruled that Congress banned discrimination based on sex, and that if a biological man dressed in a feminine fashion or a biological woman dressed in a masculine fashion, and either of those persons were fired because of those traits, it would be discrimination based on sex. He went on to explain, "Some of those who supported adding language to Title VII to ban sex discrimination may have hoped it would derail the entire Civil Rights Act. Yet, contrary to those intentions, the bill became law. Since then, Title VII's effects have unfolded with far-reaching consequences, some likely beyond what many in Congress or elsewhere expected. But none of this helps decide today's cases. Ours is a society of written laws. Judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions about intentions or guesswork about expectations. In Title VII, Congress adopted broad language, making it illegal for an employer to rely on an employee's sex when deciding to fire that employee. We do not hesitate to recognize today a necessary consequence of that legislative choice. An employer who fires an individual merely for being gay or transgender defies the law." This was an enormous decision, and I had a tough time putting this forth. But I think that there are 3 more decisions that potentially affect more people in bigger ways than this decision. For my 3rd most important decision of the year, I have McGirt v. Oklahoma. This was a 5-4 decision with Justice Gorsuch joining what was the liberal wing of the court. I will say that I do not believe this case would be decided the same way if the new court heard it. The core holding of this decision is that much of eastern Oklahoma remains Native American territory and subject to federal, not state, criminal law. That may not sound like a big deal, but it is. Plain and simple, the FBI does not come running to your house when there's an issue, and you do not see a whole lot of federal rape prosecutions, which is what was at the heart of this case. Legally, this case really came down to statutory interpretation. In 1833, Congress established a reservation, and Oklahoma claimed that over time, Congress had disestablished the reservation, and there was a strong argument for that point set forth in Chief Justice Roberts' dissent. The majority held otherwise. The real stake in this case was set forth by Justice Gorsuch when he wrote, "Still, the stakes are not insignificant. If Mr. McGirt and the tribe are right, the state has no right to prosecute Indians for crimes committed in a portion of northeastern Oklahoma that includes most of the city of Tulsa. Responsibility to try these matters would fall instead to the federal government and tribe. Accordingly, for Native Americans that commit crimes in much of Oklahoma, including rape and murder, the state of Oklahoma would have no jurisdiction to hold them accountable. Given many tribes' refusal to prosecute members for practically any crimes, and the feds' unwillingness to get involved for all but the most egregious, that makes for somewhat of a dangerous situation for non-natives in eastern Oklahoma. In addition, there are some other ramifications for this case that I am not going to get into, but to sum up, I think that at some point in the future, Congress is going to have to address this issue, which will likely cause an uproar. I will also say that the issues in this case are extremely close, so the 5-4 decision was not surprising. That brings me to my second most important case, which is Roman Catholic Diocese of Brooklyn, New York v. Como. This was the first case where the court overturned a COVID restriction, and I suspect it will be the first of many. I had an entire video on this case already, which should be up in the corner now. This case was decided the day before Thanksgiving, timing that I suspect was not a mistake, and appears to be a 5-4 decision. The majority decision is unsigned, but Justices Breyer, Kagan, and Sotomayor, along with Chief Justice Roberts, dissented. The heart of the ruling was that Governor Cuomo could not enforce any capacity limits on churches due to ongoing pandemic until a final decision of the Second Circuit, and if necessary, an additional petition for certiorari to the Supreme Court. The court made it very clear that it believes the restrictions imposed by Governor Cuomo are unconstitutional. In several rulings since, the court has made clear that COVID restrictions will be subject to a lot more scrutiny. That includes the recent Danville Christian Academy v. Bashir, where the court did not strike down the restriction at issue, but warned Kentucky Governor Bashir that if he should renew the order that was at issue in that case, which was set to expire very shortly, it will be subject to review and likely struck down. Some of the most cited language from this opinion comes from Justice Gorsuch's concurring opinion, where he directly attacks the court's 1905 decision in Jacobson, which allows states to encroach on certain liberties during times of pandemic, and has been read to allow for mandatory vaccinations. Why have some mistaken this court's modest decision in Jacobson for a towering authority that overshadows the Constitution during a pandemic? In the end, I can only surmise that much of the answer lies in a particular judicial impulse to stay out of the way in times of crisis. But if that impulse may be understandable or even admirable in other circumstances, we may not shelter in place when the Constitution is under attack. Things never go well when we do. Especially during the ongoing pandemic, which is hopefully coming to an end soon, this case is extremely important and likely impacts every person living in the United States. It is hard to top a case striking down a COVID restriction for most important case of the year, and I actually thought long and hard about making the next case my second most important. But this case appears set to literally rewrite politics in this country. My most important case of the year is Trump v. New York. The decision for this case came down yesterday, December 18th, 2020, and I already did a video on this case where I basically called how this case would go. There's going to be a video just on this case as well, which should be up on the channel shortly, so I'm only going to cover the case from a 10,000-foot view. In a 6-3 per curiam decision, which means it was unsigned, the court held that the challengers did not have standing to challenge a memorandum from President Trump which directs the Secretary of Commerce to estimate and exclude the number of undocumented immigrants from the census for each state. The ramifications for this are enormous. If President Trump is successful, it will change the allocation of federal funds significantly. It will also affect the apportionment of representatives in the House, with more representatives going to red states and less to blue states. Finally, it will make it far more difficult for Democrats to hold the House of Representatives and diminish the power of California and New York substantially. Some key language from the majority opinion is, a foundational principle of Article 3 is that an actual controversy must exist not only at the time the complaint is filed, but through all stages of the litigation. As the plaintiffs concede, any chilling effect from the memorandum dissipated upon the conclusion of the census response period. The plaintiffs now seek to substitute an alternative theory of a legally cognizable injury premised on the threatened impact of an unlawful apportionment on congressional representation and federal funding. As the case comes to us, however, we conclude that it does not, at this time, present a dispute appropriately resolved through the judicial process. As I'm going to cover this case in more detail in another video, I will leave it with this. President Trump gets to present the census, which he inevitably will, and a lot more litigation is going to follow. That is all I have for you in this video. I note that this is the second of 3 videos in this channel's 300 subscriber giveaway. The winner will be announced on Thursday, Christmas Eve. So make sure that you watch the video about how to be considered for the giveaway. That video is in the description below. I hope that you enjoyed this video. It took a ton of research to pull together. If you did enjoy the video, a like would be very much appreciated. And if you want to see more content like this in the future, please subscribe and turn on notifications. Take care of yourself, your friends, and your family during these crazy times. I will not have another video up before Christmas, so have a wonderful holiday. And last but certainly not least, have a great day. Bye-bye.